Welcome. Today I'll be talking about the case of Silberberg and Builders Collective of Australia Incorporated. The applicant in this case was Mr. Ron Silberberg. He identified himself as being a member of the Jewish race and of Jewish ethnicity. He was the Managing Director of the Housing Industry Association, or the HIA. The first respondent in this case was the Builders Collective of Australia Incorporated. The collective ran a site which included a forum relating to the building industry, and the forum's topics primarily related to debates about warranty insurances in the industry, and only registered users could post on the forum, both Australian and overseas users. The terms and conditions of the membership authorised the collective to remove data that violated their policies, and the user had to agree to not post hate speech and other harassing messages. Messages were posted automatically on the forum without intervention by the collective, and it was a policy of the collective to delete objectionable material once made aware. The second respondent, Mr. Ken Buckley, was a registered user in the forum and wrote racial messages towards Silberberg because of his Jewish ethnicity. It was implied that because he was Jewish, he had an excessive monetary focus within the HIA, and that he had exercised control over the building industry as a means of making money for himself and his rich friends at the expense of the membership of the HIA. These messages were deleted by the collective several months later by reason of a letter sent by Silberberg's solicitor. It was found that 1 month prior to the removal of the messages, an administrator of the forum had seen and responded to one of the messages. Justice Giles was satisfied that the response by the admin was sufficient to indicate that the admin read the message and of the racial imputation underlying the message. The relevant legislation in this case was Section 18B, Section 18C, and Section 3, Subsection 3 of the Racial Discrimination Act 1975. The case against Buckley was simple. Justice Giles held that the messages were an act of publication, following the case of Jones v. Tobin, and that they were reasonably likely to offend, insult, humiliate, or intimidate Silberberg or other Jewish people, and this was the objective test, which was satisfied under Section 18C of the RDA. And lastly, the reason for publishing the messages was explicitly because of Silberberg's Jewish ethnicity, and Section 18B of the RDA was satisfied. The case against the collective was a lot more complex. The question that the court had to answer was whether the collective breached the RDA because they published and/or allowed the messages to be published on the forum. In making his judgment, Justice Giles referred to a number of different cases that involved different kinds of liability for intermediaries for different types of technologies. So, for example, newspapers. And in this case, he held that in a defamation case, the collective would be held responsible, even if it was only an agent who knew of the offensive messages, because they chose to run an open, anonymous forum available to the world without any system for scrutinising what was posted. He then held a party in a controlling position of such a website of such a nature is not different to publishers of other mediums. So, for example, like a newspaper. His Honour then concluded on the issue and stated that the failure to remove such material in those contexts would be an act caught by the RDA if the reason for failing to remove it was because of racial vilification. However, in this case, no connection could be made out between the failure to remove and Silberberg's race or ethnicity because it was a lack of diligence rather than racial vilification on part of the intermediary. Accordingly, the case against the collective was dismissed, but the case against Buckley was successful. Thank you for listening.